Welcome to the module on legal issues, federal regulations, and accreditation. Before we explore these topics, we must ground ourselves in the discipline that powers every hospital dashboard and bedside scanner: health informatics. Health informatics is the deliberate collection, refinement, and interpretation of clinical and administrative data so that caregivers can turn raw numbers into life-saving decisions and efficient workflows. It works as the circulatory system of modern care, delivering the right knowledge to the right professional at precisely the right moment. Because informatics bridges clinical practice and technology, it operates within a triad of constraints that set both limits and expectations. The first layer is national law. Statutes such as the Health Insurance Portability and Accountability Act that grant patients privacy rights and impose security duties on institutions. The second layer is agency rulemaking. Bodies like the Centers for Medicare and Medicaid Services and the Office for Civil Rights translate legal intent into detailed rules that govern data sharing, breach reporting, and software certification. The third layer is accreditation. Independent evaluators, including the Joint Commission, convert both law and regulation into survey criteria that shape contracts, reimbursement, and professional liability coverage. Imagine a chief information officer in a regional hospital who plans to roll out home monitoring for heart failure patients. Informatics specialists can build a cloud platform that streams vital signs into the electronic record. However, the launch cannot proceed until a signed contract ensures privacy protections. Federal interoperability rules are met, and accreditation files demonstrate that alert thresholds align with current evidence. Neglecting any one layer can stall the project, deplete budgets, and erode public trust. Mastering health informatics, therefore, means mastering this intertwined legal, regulatory, and accreditation ecosystem. After grounding ourselves in the vital role of health informatics and its regulatory guardians, we now turn to the compass that will steer the rest of our journey. Today's objectives slide. By the end of this module, you will be able to describe the governmental structure of the United States and the legislative path that shapes oversight of a health information technology, distinguish between primary statutes, implementing regulations, and the sub-regulatory guidance issued through bulletins and advisory opinions, apply fraud and abuse provisions of the Health Insurance Portability and Accountability Act and related statutes to electronic health record workflows, summarize the accreditation measures and reviewing bodies that govern information systems in this country, and discuss how cloud computing, artificial intelligence, and consumer digital tools are rewriting the rulebook for every hospital leader. Why does this list matter for a manager? Because each objective translates into a decision you must make before the ink dries on a technology contract. Picture yourself directing information systems in a regional medical center where clinicians request a voice-enabled documentation platform powered by machine learning. You will first map the tool against federal fraud safeguards to ensure no hidden upcoding incentives exist, verify whether the Centers for Medicare and Medicaid Services has issued interpretive guidance on data blocking, and prepare evidence for your following Joint Commission survey proving that alert thresholds and audit trails align with current accreditation standards. Skipping any step could stall the project, draw penalties, and erode public trust. Mastering these objectives is therefore not a theoretical exercise. It is a blueprint for safe, compliant, and forward-thinking leadership in healthcare. Be sure to read the assigned materials for this unit, as the statutes, case studies, and accreditation manuals they contain will bring these goals to life, building on the objectives we just mapped out. Let us now turn to the architecture that gives those objectives legal force: the three branches of the federal government. Understanding how each branch shapes health information technology is essential for every manager who signs a data sharing contract or approves a clinical software upgrade. Begin with the legislative branch. Elected representatives introduce bills, debate their social and fiscal impact, and finalize the statutes that form our compliance baseline. The Health Insurance Portability and Accountability Act, for instance, was born in this forum, and its privacy provisions set the guardrails for every electronic record you deploy. Next comes the executive branch, the administrative engine that turns congressional intent into daily practice. Departments such as Health and Human Services draft regulations, issue interpretive bulletins, and run enforcement programs. When you read a rule on breach notification timeframes or certification criteria, you are seeing the executive branch at work. Finally, the judicial branch resolves disputes over meaning and scope. When hospitals contest the reach of a privacy rule, federal judges deliver binding interpretations that can expand or contract your obligations overnight. Why does this triad matter in your day-to-day leadership? Imagine you wish to integrate an artificial intelligence decision tool into your intensive care workflow. You must verify that the enabling statute permits machine-generated recommendations, ensure that the latest executive regulations on transparency and bias are met, and monitor ongoing court cases that could redefine liability if a recommendation harms a patient. Neglecting any branch could expose the organization to legal risk and reputational damage. As you move through today's readings, pay close attention to how legislative text, executive regulation, and judicial opinion interact. Mastery of that interplay will enable you to navigate technology projects with confidence and foresight. Building on our exploration of the legislative, executive, and judicial branches, we now widen the lens to examine a deeper structural principle, federalism and the Constitution. This topic explains why a single hospital must navigate both federal privacy statutes and state licensing boards, and why a city health department can issue emergency ordinances even while national agencies set broad data standards. Federalism divides authority between national, state, and local governments. In practice, this means Washington sets baseline rules for the protection, exchange, and funding of health information, while states decide matters such as professional licensure, public health reporting, and Medicaid program design. Understanding this distribution, health managers anticipate when a project will require state approval in addition to federal compliance checks. The Constitution supplies the blueprint. It establishes the three branches we discussed earlier, defines their powers, and reserves all non-conflicting authority to the states. Some powers are express, clearly listed, such as the congressional power to regulate interstate commerce, which justifies nationwide data blocking rules. Others are implied, drawn from broader language, such as the power to create conditions on federal grants that drive statewide adoption of electronic record systems. Knowing which type of power is in play guides your strategy when a regulation seems open to interpretation. Consider a health system that wants to launch a regional patient data exchange spanning 4 states. The manager must confirm that the exchange meets federal privacy and security standards, but must also reconcile each state's consent laws and breach notification timelines. Success lies in recognizing where the Constitution grants national supremacy and where state prerogatives prevail. As you prepare for our next session, read the assigned chapters and case decisions. They will help you see how this constitutional framework shapes every contract, policy, and technology rollout you oversee. Now that we have explored how federal and state powers intertwine under the Constitution, let us move to the practical machinery that turns constitutional authority into day-to-day requirements, the Federal Healthcare Regulatory Framework. Think of this framework as the operational backbone that converts lofty policy goals into the checklists and dashboards you manage on a weekly basis. It begins with laws. When Congress passes a statute, it outlines broad objectives such as safeguarding patient privacy or encouraging digital transformation. Crucially, the statute rarely prescribes exactly how hospitals must comply. That responsibility falls to the executive agencies. Once an agency receives legislative authority, it launches a rule-making process. Draft rules are published, comment periods invite feedback from clinicians, vendors, and citizens, and revisions follow. When a final rule appears in the Federal Register, it becomes a binding regulation enforceable through audits, fines, and funding consequences. Agencies may also release advisory opinions and guidance documents. These are not legally binding, yet they illuminate gray areas and often forecast future enforcement priorities, making them essential. Reading for risk-averse managers. Why should this matter to you? Imagine your health system wants to deploy a cloud-based decision support tool. You must confirm that the software's data flows align with statutory privacy mandates, review the newest agency regulation on interoperability, and consult guidance documents that clarify acceptable machine learning transparency standards. Acting on that trio, law, regulation, guidance, allows you to anticipate audits, negotiate stronger vendor contracts, and protect both patients and the organization's reputation. As you progress through this module, be sure to read the assigned statutes, rules, and agency memorandum. They provide the real-world examples and interpretive clues that will help you apply today's framework to tomorrow's projects. Let us now move from the architecture of rules to the forces that police those rules. The slide before you, titled Law Enforcement, shows how compliance in healthcare is upheld after the ink dries on a regulation. In our previous discussion, we traced how statutes become binding rules. Here we examine what happens when those rules are ignored. The first channel is administrative enforcement. Many health statutes embed a self-policing system that triggers audits when reporting thresholds are missed or when a patient files a complaint regarding privacy. An agency such as the Office for Civil Rights can investigate, impose corrective action plans, and levy significant monetary penalties without ever stepping into a courtroom. For a manager, this means that day-to-day documentation must withstand surprise inspections. A sloppy breach log or an incomplete risk analysis can open the door to fines that erode margins and invite public scrutiny. The second channel is the federal court system. Litigation may begin there if an agency decision is appealed or if criminal conduct is suspected. When an indictment alleges intentional fraud, the matter starts in a federal trial court and can climb to an appellate bench, shaping precedent for every hospital in the circuit. Court findings often reinterpret vague regulatory language, transforming best practices into mandatory standards overnight. Consider a chief compliance officer who discovers that staff have been copying medication summaries onto unsecured flash drives. An administrative inquiry could impose six-figure penalties. If prosecutors believe the breach was willful and involved identity theft, formal charges would move directly into federal court, adding potential prison time to the financial loss. Understanding both tracks allows managers to calibrate response plans and training budgets before minor lapses escalate. Be sure to read the assigned agency reports and case opinions. They reveal how enforcement bodies think and will prepare you to navigate real-world investigations with confidence. Building on our conversation about how agencies and courts enforce compliance, We now focus on a set of prohibitions that lie at the heart of healthcare integrity, fraud, and abuse. Mastery of these rules is not optional. It is what separates innovative leadership from costly scandal. Begin with physician self-referral. The Stark Law prohibits a clinician from referring a patient to an imaging center, laboratory, or therapy practice in which the clinician or an immediate family member has a financial interest, unless a specific exception applies. The intent is straightforward. Medical decisions should be based on evidence, not on ownership. Next is the federal statute that outlaws kickbacks. It forbids offering, soliciting, or accepting anything of value to influence the referral of a patient whose care is paid, even in part, by a federal health program. Think gift cards, inflated consulting fees, or free office space all can trigger liability if their purpose is to pump up referrals. Safe harbors act as narrowly drawn escape hatches. Structured correctly, fair market leasing, group purchasing, and properly disclosed gain-sharing arrangements can fall within these protections. Miss a single documentation clause, however, and the safe harbor vanishes. Overlaying these rules is the False Claims Act, which empowers whistleblowers and federal prosecutors to recover treble damages for bills that violate the Stark or kickback statute. Wire and mail fraud statutes provide additional criminal hooks when false statements travel across state lines. Imagine a hospital exploring a telecardiology partnership. To attract cardiologists, the vendor offers subsidized tablets. Before accepting, the compliance manager must test the arrangement against the kickback statute, verify whether a safe harbor for technology donations applies, and establish a documentation file that can withstand a False Claims Act audit. Neglecting these steps could result in multi-million-dollar penalties and exclusion from federal programs. We have just surveyed the statutory landscape of fraud and abuse. Now, our attention shifts to its digital battleground, the world of fraud and abuse within the electronic health record. This title signals a crucial reality. Every click in a record system can either safeguard or sabotage ethical billing. Digital documentation makes it alarmingly easy to charge for services that were never provided or that were clinically unnecessary. One common tactic is unbundling, separating procedures that should be grouped under a single current procedural terminology code to prevent multiple charges from inflating revenue. Because these manipulations occur within the record interface, they can be difficult to spot until a payer audit or whistleblower complaint forces a painful reckoning. Fortunately, the same technology that enables misconduct also offers strong defenses. Modern record platforms record who changed what and when. They highlight excessive copy and paste use, and they generate exception reports that flag suspicious billing patterns. Yet tools alone are insufficient. A robust compliance program must set explicit standards of conduct. Audit logs must be reviewed by someone with authority to act. And every employee, physician, coder, and receptionist alike must understand the financial and legal stakes of digital documentation. Consider a director of revenue integrity who discovers that emergency department clinicians are systematically copying the previous day's note for then adding a single line to justify a higher evaluation and management level. The director deploys an audit log dashboard that identifies repeated text blocks, convenes focused education sessions on correct current procedural terminology coding, and updates the hospital's standards of conduct to require attestation for each reused template. By combining technology with policy and training, the organization addresses risk before a payer or prosecutor steps in. Having explored how electronic records can either curb or cultivate fraudulent billing, Our next focus is the guardrails that govern institutional practice at a higher level: hospital accreditation for Medicare and Medicaid. Accreditation is not simply a certificate for the wall. It's the key that unlocks federal reimbursement and signals to patients, payers, and regulators that your facility meets rigorous quality and safety benchmarks. Two national accrediting bodies dominate this space. First, the Norske Veritas Healthcare integrates international risk management principles with United States clinical standards, conducting annual surveys instead of the traditional 3-year cycle. Second, the Joint Commission uses its long-standing survey model to evaluate hospitals against a broad set of criteria that now includes detailed requirements for information governance. Both programs examine 4 domains that every manager must understand: planning for the management of information, ensuring accurate use of health information, leveraging knowledge-based resources for clinical decision-making, and continuously monitoring the data lifecycle to detect gaps or errors. Why does this matter in your daily leadership? Imagine you serve as Vice President for Clinical Operations and your hospital is preparing for its next Joint Commission visit. A sentinel event involving medication error has been traced to a configuration flaw in the electronic record. To retain accreditation, you must document corrective action, demonstrate that audit logs validate the fix, and show how ongoing monitoring will prevent recurrence. Failure could jeopardize both Medicare and Medicaid contracts, erode public trust, and trigger costly remediation plans. As you study the assigned accreditation manuals and case studies, pay particular attention to the information standards. They translate the fraud prevention principles from our previous discussion into measurable expectations, ensuring that technology supports, not undermines, patient safety and organizational integrity. Please read the designated materials before our next session so that you can apply these concepts to your own compliance roadmap. As we leave the broad topic of accreditation and reimbursement, let us examine the practical lessons offered by the Joint Commission. Findings and recommendations. The latest survey cycle has identified 3 systemic weaknesses in health information technology. First, breakdowns at the human-computer interface, confusing screens, cryptic alerts, and poorly placed buttons lead clinicians to click past critical warnings. Second, workflow and communication gaps reveal that even a well-designed system will fail if the surrounding processes do not support timely data exchange among nurses, physicians, and pharmacists. Third, design flaws in clinical content and decision support modules can propagate outdated guidelines or offer irrelevant advice, undermining trust in the entire platform. The Joint Commission does not simply list these faults, it charts a path forward along 3 reinforcing avenues. A culture of safety asks leaders to reward the reporting of usability hazards rather than dismiss them as user error. Continuous process improvement turns those reports into iterative fixes using rapid cycle testing rather than annual overhauls. Finally, visible leadership involvement signals that information governance is a strategic priority, not a back-office chore. Imagine you are the chief nursing officer preparing for a follow-up survey after a medication ordering sentinel event. You convene a multidisciplinary task force, invite bedside nurses to demonstrate where decision support alerts interrupt workflow, and empower informatics analysts to redesign the screen sequence. You then schedule monthly huddles where executives review new interface metrics alongside infection control data. This triple focus on culture, process, and leadership transforms survey findings from a compliance burden into a catalyst for safer care. To apply these insights in your organization, study the detailed reading materials assigned for this module. They provide case studies and toolkits that will help you translate recommendations into measurable improvements before the next survey team walks through your doors. Building on our discussion of Joint Commission findings, we must now confront a fast-moving frontier, new technology and regulation. The subtitle could read, Innovations Outpacing the Rulebook, because no single federal body has full authority over the expanding universe of health information technology. Consider the spectrum. Telehealth brings clinical expertise into living rooms, yet oversight is divided among state licensing boards, the Federal Communications Commission, and the Centers for Medicare and Medicaid Services. Software as a medical device, diagnostic algorithms, and those calculators that run on tablets falls partly under the jurisdiction of the Food and Drug Administration. However, cybersecurity guidance may originate from the National Institute of Standards and Technology. Mobile health applications collect step counts and glucose readings. Some are deemed wellness tools, others are regulated products, and the dividing line shifts with each innovation. Even social media, once peripheral to care, now hosts patient communities and marketing campaigns that raise concerns about privacy and advertising. Why does this fragmented landscape matter to managers? Imagine your health system wants to launch a remote dermatology service that uses a smartphone camera, a cloud-based image analyzer, and an online follow-up portal. You must verify telehealth licensure across state lines, confirm whether the image analyzer meets the Food and Drug Administration software classification, ensure mobile privacy notifications, satisfy Federal Trade Commission expectations, and establish social media guidelines for sharing before and after photos. Missing any piece can delay rollout, attract fines, and damage public trust. The key takeaway is that vigilance, cross-departmental collaboration, and early legal consultation are crucial when new tools arrive faster than regulations can be implemented. As you prepare for our next session, read the assigned statutes, guidance documents, and case studies. They will help you anticipate regulatory gaps and turn uncertainty into a strategic advantage. Here we stand at our closing slide, formally labeled Summary, though I prefer to view it as our launchpad for action. In the last segment, we saw how innovation can outpace the rulebook. Now, we weave the entire journey into one coherent picture, so you, as healthcare leaders, can transform knowledge into sustainable governance. Across this module, we explored the three federal branches shaping health information governance, the constitutional sharing of power with states, and the rulemaking process turning statutes into enforceable regulations. We learned how agencies audit compliance, how courts restore clarity, and how fraud and abuse laws, police referrals, billing, and electronic documentation. We examined technical safeguards within record systems, the accreditation demands of De Norsky Veritas and the Joint Commission, survey findings on human-computer design flaws, and leadership paths to remedy them. Finally, we surveyed emerging telehealth device software, mobile applications, and social media, noting that innovation often outruns coordinated oversight. Why does this synthesis matter? Every strategic initiative, whether a predictive analytics program or a virtual intensive care unit, will be evaluated at the intersection of legal, technical, and cultural factors. Picture embedding a conversational decision support tool on bedside tablets. You will cross-check its incentive structure against self-referral and kickback rules, validate algorithm transparency through guidance from the Food and Drug Administration, update Joint Commission information standards, and train clinicians to avoid unsafe copy and paste. Coordinated attention across these domains turns potential liability into a competitive advantage. Your next step is to translate these principles into practice. Begin by reviewing the statutes, regulations, advisory bulletins, accreditation manuals, and case studies listed in the textbooks. Please read them carefully, annotate them, and discuss them with your teams. The regulatory environment will continue to evolve. Proactive mastery will enable you to guide that change rather than chase it.